My name's Stephanie Slone. This is my speech for Communication 101. 911, what's your emergency? I have a protective order against my boyfriend, and he's back to living with me, and we had a fight, and now I want the police to come and get him because he's violating the protective order. This is a daily occurrence across the state of Indiana regarding protective orders that police officers are forced to deal with. We're not talking about victims of domestic violence and those who are protecting children who truly want to stop the violence and rebuild their lives, but about the abusers of the legal system. The victims, for what they call themselves, for whatever reason, decide they need to get a protective order against their significant other because they equally fight and equally abuse each other and say they want to hold the upper hand on the relationship. Some people feel that women are using protective orders to manipulate the system. In fact, Pamela Pross states in her article, Domestic Violence, some conservatives also argue that women who seek help from domestic violence legal programs get an edge in their custody or divorce proceedings. VAWA has little to do with violence and much to do with divorce court. Family law attorney Scott wrote, McCormick of the American Coalition for Fathers and Children say abused women who turn to shelters do not get counseling first, but instead are directed to the courthouses to get a restraining order, which helps them in the divorce or child custody case because judges will view the man as abusive and dangerous, even if he's not. These types of petitioners of the protective order seek drama, attention, sympathy, and setting up when they're trying to dispute child custody. This is just one of the several reasons that I am pushing for new laws to ensure that this type of abuse stops. Indiana needs to create new legislation that not only binds the respondent to following the no-contact order associated with the protective order, but to the petitioner as well, to be legally required to follow the no-contact order. An order of protection comes in many forms. It prohibits the respondent from committing violent acts, prohibits harassment, it orders the respondent to stay away from the petitioner, it evicts the respondent from the home, and it orders the respondent to favor various things, and prohibiting the respondent from carrying firearms. The petitioner is the person who is seeking protection through the order of protection. They are victims of domestic violence or family violence, victims of stalking, or victims of sex offense, and the respondent is the person who is allegedly committing the violent acts. The Indiana Civil Protection Order Act was passed to protect all victims of domestic family violence, sexual assault, and stalking to prevent future violent acts. It was the intended purpose. However, in years since, abuse of the Protection Act, phone calls, and court cases continue to rise year after year. Since protection can be granted with little or no evidence, some residents see this as a stepping stone after arguments and fights are no longer giving them the results they are seeking. To them, filing a restraining order, as it's commonly referred to, is just another battle they are determined to win in this love-hate war relationship. Indiana needs to create new legislation legally binding not only the respondent, but the petitioner as well to the no-contact rule. This law would change the way police and the courts could handle these abusers of the protective order by holding both parties legally responsible. The current law allows the petitioner to have all the contact they want with the respondent. They can say they forgive the respondent for their violent acts and take them back, thus encouraging the respondent to violate the order. It's when later in the day, week, month, or even that year, they have a fight, the petitioner calls the police complaining the respondent is violating the protective order. How is this a fair and just legal system? Other situations have risen when the petitioner entraps the respondent by making them believe they want to see them and rebuild their life, only to set them up by having the police on speed dial the minute the respondent shows up. A way to clear this loophole would be for making it illegal to either party to have contact. Another benefit this new proposed law would offer would be to the encouragement to the petitioner. By taking away the option of the petitioner contacting the respondent, it would encourage them to make a clean break from the respondent. Currently, respondents who violate the protective order can face arrest, fines, and jail time. Modifying the law to legally making the petitioner equally responsible to follow the no-contact order and to hold the petitioner to the same fate as the respondent for the legal ramifications would only make it easier. No contact allowed by both parties would be one more reason that the petitioner would be able to make better choices and changes for the life. Knowing they no longer have a choice to contact the respondent gives them no choice but to move forward. Currently, there is no minimum evidence required for a protective order. The petitioner is encouraged to bring proof in the form of witnesses, police reports, pictures, objects, and weapons used in the act. The petitioner will complete the petition, supply any evidence, and go before a judge. When the order is protection is granted, the respondent must be served before it's enforceable. Usually a protective order is good for 2 years. Once the protection order is issued and served, current Indiana law prohibits the respondent from contacting the petitioner. This is where Indiana law must be modified, prohibiting both parties any contact. This would encourage both parties have no option but to separate and maintain the no contact order and move on with their lives. The current law allows the petitioner to change their mind, contacting the respondent to forgive, and encourages the cycle of violence to continue. Thank you.